Hey everyone, let's jump right into this explainer. Today we're looking at your workplace benefits. Specifically, we're taking the really dense, kind of dry language of business law and translating it into practical knowledge about your financial safety net. If you've ever stared at your pay slip and wondered about the whole complex web of laws and statutory schemes that are supposedly protecting your future, well, you're in the exact right place. We're going to unpack the nuts and bolts of the Employees Provident Funds Act, zooming in heavily on Sections 6A and 6C. Okay, let's dive into this. I actually want to start off with a quick question for you. Who do you think really pays for your pension under Section 6A of the Act? When we talk about the employee's pension scheme, most of us naturally assume it's, a 50-50 split between us and our boss, right? Or maybe you think it comes entirely out of your own take-home pay. Take a second. What's your assumption? Well, the answer is a big, surprising zero. Yeah, no way, right? But as an employee, you contribute absolutely nothing, $0, to the employee's pension scheme itself. It's actually funded entirely differently, which is a massive statutory benefit for the workforce. And that's exactly the kind of thing we're going to break down for you completely today. So here's our quick roadmap for this explainer. 1. The statutory safety net. 2. The employee's pension scheme, specifically 6A. 3. Funding the pension. 4. Managing the pension fund. 5. The deposit-linked insurance scheme under 6C. And finally 6. Security for the future. Section 1. The statutory safety net, framing the problem and solution. The source text actually captures the whole overarching purpose of the Act perfectly. It says, these schemes taken together provide to the employees an old age and survivorship benefits, a long-term protection and security to the employee, and after his death to his family members. So look, this isn't just a bunch of bureaucratic red tape. It's literally a legally mandated security blanket, and it's designed to protect your family comprehensively. Moving on to Section 2, Employees Pension Scheme, or 6A, your coverage. And this brilliantly illustrates how the central government didn't just plan for standard retirement. The scheme actually serves 4 distinct purposes. First off, there's the superannuation pension. That's for when you retire normally. Second, a retiring or permanent total disability pension, just in case you can't work anymore due to a severe injury. Third, a widow or widower's pension to protect your spouse. And fourth, a children or orphan pension payable to your beneficiaries. So it's really this holistic shield for an employee's entire family life cycle. Now, you might be wondering, how long does this coverage actually last? Let's trace the timeline. On day 1, the exact moment you start working for a covered establishment, boom, the coverage kicks in. Throughout your working years, it continues, and the law specifically notes these provisions can take effect either prospectively or retrospectively. But here's the absolutely crucial rule you have to remember. Once you hit exactly 58 years of age, the scheme legally ceases and all contributions strictly stop. So it's a very firm, defined legal boundary. All right, Section 3. Funding the pension. Who pays what? So the crucial point is your employer is the one bearing this specific financial burden. By law, the employer must contribute 8.33% of your basic wages, dearness allowance, and retaining allowance right into the pension scheme. It's totally mandatory. Your personal take-home pay is not taking a hit to fund this specific 6A pension scheme. It's completely an employer liability. Section 4. Managing the pension fund. Bureaucracy with a purpose. Okay, if you read Schedule 2 of the Act directly, it is super dense. But we've grouped the key mandates logically so you can actually see the real purpose behind all this bureaucracy. The Central Board determines your minimum qualifying service. And this is huge. They're legally mandated to protect your interests as an employee, even if your employer defaults on their payment. They also keep the accounts, follow really strict central government investment patterns to grow the funds safely, and they regulate the scales of the pension and exactly how that money gets dispersed to you. It's a tightly controlled system designed entirely for your protection. Section 5. Deposit-linked insurance, or 6C, protecting against the unforeseen. Now, this specific scheme originally kicked in back in September 1976, and we've seen a pretty massive evolution in its wage ceiling limit since then. In the past, the old wage ceiling limit was just 6,500 rupees. But, to adapt to modern economic realities, that ceiling was bumped up to 15,000 rupees, which is fantastic because it means the insurance scheme expanded its umbrella to cover higher wages, offering that critical protection to a much larger chunk of the workforce. Now, what's really interesting about this are the specific parameters of Section 6C. First, it applies to all covered establishments, but get this, there's a highly unique historical exclusion. it does not apply to tea factories in the state of Assam. Kind of quirky, right? Second, the actual insurance benefit payout if the worst happens is quite substantial, an amount between 2.5 lakhs and 6 lakhs. And third, to actually fund this deposit-linked insurance fund, your employer pays a maximum of 1% of the aggregate of your basic wages, dearness allowance, and retaining allowance. Section 6, Security for the Future. Putting it all together. Let's do a quick mental exercise to translate those 8.33% and 1% rules into real-world math. Say we have a hypothetical basic wage of 10,000 rupees. Under the Section 6A pension scheme, your employer pays 8.33%, so that's an 833 rupee contribution. Under the Section 6C insurance scheme, the employer pays up to 1%, which is 100 rupees. But wait, what if your wage is over that 15,000 rupee mark? Well, the insurance contribution is legally restricted to the amounts payable on that 15,000 rupee ceiling. It caps out right there, which keeps the whole system balanced and totally predictable. And just to show you how incredibly comprehensive this employer liability truly is, the law explicitly states that employers must also pay an additional amount, up to 1/4 of their insurance contribution, purely to meet the administration expenses of the scheme. The central government ensures that the cost of running all that bureaucracy doesn't eat into the actual benefits meant for you. So again, the financial burden on the employee, it remains at absolute zero. Okay, picture this. Imagine a hypothetical company, let's just call them Acme Corp, and they get a formal notice. Suddenly, they're in a fundamental disagreement with the employee's Provident Fund, the EPF. Now, maybe they're arguing that the EPF Act doesn't even apply to their workers in the first place. Or maybe they agree it applies, but they are clashing hard over the exact math, the actual amount of employee dues that need to be paid out. Well, this isn't just some minor administrative hiccup, right? It's not a quick email thread you can just brush off. This exact scenario actually kicks off a rigorous, highly structured legal process, and it carries huge real-world stakes for both the company and, most importantly, the actual livelihoods of the employees who rely on those funds. So, welcome to this explainer. Today, our whole goal is to take what looks like really dense, honestly intimidating legal procedure and translate it into a clear, chronological roadmap for you. We're going to examine the exact nuts and bolts of how employee funds are calculated, how they're disputed, and ultimately how they are fiercely protected under the law. We'll be walking step by step through the life cycle of a single EPF dispute, starting right at Section 7A and going all the way through to Section 10. All right, let's dive right into this. Here is our agenda for today. First, we'll look at the initial EPF inquiry. Second, requesting an order review. Third, catching escaped amounts. Fourth, the EPF Appellate Tribunal. And finally, we'll wrap up with the total protection of funds. Starting us off, Section 1, the initial EPF inquiry, which falls under Section 7A. So when our Acme Corp and the EPF disagree on whether the act actually applies, or they just can't agree on the final bill, the EPF authority steps in to conduct a formal inquiry to decide the dispute. And listen, you really shouldn't mistake this for some casual sit-down meeting. For the purpose of this inquiry, the EPF authority acts exactly like a civil court. I mean, under the Code of Civil Procedure, they hold immense power. They can legally enforce the attendance of any person and examine them under oath. They can require the mandatory discovery and production of internal company documents. They can receive formal evidence on affidavits and even issue commissions to examine witnesses. They literally have the full legal toolkit to demand the truth from an employer. Now, knowing all that power exists, what if Acme Corp decides, you know what? We're just going to avoid the hassle. What if they just ghost the proceedings and fail to attend the inquiry? Well, the authority isn't just going to pack up their briefcases and go home. They will decide the case ex parte. If you're not familiar with that term, an ex parte order is basically a decision the authority makes based solely on whatever documents have already been put in front of them. It is the direct, heavy consequence of failing to show up. You simply lose your voice in the room. And if Acme Corp does get hit with that ex parte order, the clock starts ticking fast. See that massive 3 on your screen? The employer has exactly 3 months from the date the order is communicated to them to apply to the authority to try and set it aside. But it's absolutely not a free pass. They have to prove there were sufficient causes that actually prevented them from attending that specific prescribed hearing date. If, and only if, the authority is genuinely satisfied with their excuse, they might set aside the ex parte order and pick a new date to proceed. Now, what's really interesting here is this crucial Supreme Court precedent from 2001, S.K. Nasiruddin BD Merchant Limited. This case clarified something fundamental. It basically said that the applicability of the Act to employees isn't somehow magically created during a Section 7A proceeding. No, the liability arises the exact moment the Act becomes applicable to those employees by law. So, therefore, what's actually happening under Section 7A is purely the determination of quantification. Put simply, the law says the liability already exists. Section 7A is really just about doing the math. Let's move on to Section 2, requesting an order review under Section 7B. Okay, so let's say Acme Corp is genuinely aggrieved by the outcome of that 7A inquiry. They aren't totally out of options. They can apply for a review directly to the officer who passed the original order. But a review is not just a chance to argue the exact same points over again just because you didn't like the answer. The grounds for this are strictly defined. You have to show you've discovered new, important evidence, and crucially, you have to prove that even after exercising total due diligence, you couldn't possibly have known about this evidence, or couldn't have produced it back when the original order was made. Other valid grounds would be pointing out a clear mistake or error apparent on the face of the record, or any other sufficient reason. Interestingly enough, the officer can also just choose to review the order on their own motion, if they're satisfied it's necessary based on those exact same grounds. And if a review application actually gets accepted, the transparency of the whole process is fiercely protected by case law. Check out this crucial 2003 ruling from Balu Fire Clay Mines versus Union of India. It states that a review is a statutory remedy, and the petition must be disposed of by a speaking order. Translating that into plain, everyday English, a speaking order means the officer cannot just stamp denied or approved on the file and move on. They have to clearly and legally explain their reasoning. They must articulate exactly why they arrived at their decision. All right, Section 3, Catching Escaped Amounts. This is Section 7C. So imagine a case concludes, everyone shakes hands, but it's later discovered that Acme Corp actually omitted certain reports, or they failed to fully and truly disclose material facts. And because of that, a portion of the dues simply escaped the officer's notice during the original inquiry. Well, the law definitely does not let that slide. The officer has a very generous 5-year window from the original 7A or 7B order to reopen the case if they have reason to believe amounts have escaped notice. They can pass appropriate orders to redetermine the correct amount due. I think this brilliantly illustrates just how incredibly persistent the legal framework is when it comes to chasing down and securing what employees are owed. Moving on to Section 4, the EPF Appellate Tribunal, covered in Section 7D. Let's see how this all builds. If a dispute still remains unresolved, it enters a sequential flow. It starts at Step 1 with the Section 7A initial inquiry. Then, Step 2 might be a Section 7B review of that order. And finally, at Step 3, if the employer is still aggrieved, they can escalate it to the EPF Appellate Tribunal. This is the heavy hitter of the appeals process. They have the ultimate power to confirm, modify, or completely annul previous orders, but only after giving reasonable opportunities for both parties to be heard. But bringing a case to the tribunal is definitely not something an employer can do lightly, say just to stall for time. Look at that massive figure on your screen, 75%. By law, no appeal by the employer shall even be entertained by the tribunal unless that employer has already deposited 75% of the total amount due from them. Now, while the tribunal can technically waive or reduce this amount for reasons they have to record in writing, this huge upfront deposit requirement really anchors the entire system back to its core philosophy. Put simply, it protects the employee's money first before entertaining endless corporate litigation. And finally, Section 5, Total Protection of Funds. This is Section 10. Okay, so we've navigated some pretty dense procedural law today, inquiries, tribunals, huge financial deposits, but Section 10 is where it all reaches its climax. This brings everything back to its ultimate purpose, the absolute, impenetrable protection of the worker's money. The law states the amount standing to the credit of any member in the Provident Fund cannot be assigned. It cannot be charged, and most importantly, it is not liable to attachment under any decree or any court order in respect of any debt or liability the member might have incurred. Basically, even an official assignee or receiver has absolutely zero claim to this money. It is legally untouchable, period.
I'm absolutely thrilled you're tuning in today because we're tackling a subject that impacts pretty much anyone who collects a paycheck. Today, we're demystifying the Employees Provident Funds Act. You'll often hear it called just the EPF Act. But look, rather than getting bogged down in endless, dry legal jargon, we're going to look at this through a really structured, highly practical lens. Employee rights versus employer repercussions. We're going to break down exactly what protections you have as a worker and the very real, very severe consequences employers face if they try to bend those rules. Okay, let's dive into this. I want you to imagine a really high-stakes workplace dispute. Picture your boss suddenly realizing they owe a hefty chunk of change for their required contribution to your Provident Fund. It's a new expense, maybe they didn't properly budget for it, so to cover their tracks and, their wallet, they decide to just shave a little bit off your basic pay. Or maybe they quietly remove a standard allowance just to balance their books. Can they actually do that? Is that legal? Well, that very question brings us directly into the heart of Section 12 of the Act, and it's going to be the foundation of our entire analysis today. To get to the bottom of this, here's our roadmap. First, protecting your paycheck. Second, what happens when you move jobs and funds? Third, the steep price of non-compliance. And finally, what happens when companies themselves commit offenses? Let's get right to it.
Part 1. Protecting your paycheck. Consider this Act I, the shield.
Now, Section 12 of our source material states exactly this. No employer shall, by reason only of his liability for the payment of any contribution, reduce, whether directly or indirectly, the wages of any employee. I know, that's a dense block of legal text, right? But in plain English, the law is putting up an absolute, impenetrable firewall around your wages. The mere existence of the EPF cannot be used as an excuse to pay you less. Let's go back to our hypothetical boss. The illegal approach is for them to reduce your basic pay, whether directly or indirectly, just to offset their new EPF charges. The law strictly, unconditionally forbids this. So, what's the legal approach? The employer has to fully absorb their legal liability for those fund contributions without ever touching your existing wages. The burden of that contribution is entirely on the employer, exactly as the law intended. Moving right along to Part 2. Moving jobs and funds. Let's talk about account portability. And this brilliantly illustrates a super common fear. What happens when you leave that boss for a better opportunity? People worry their money gets trapped when they change careers. But under Section 17A, let's walk through a concrete example. Step 1. You leave your current job at, say, a large tech firm that's covered under the EPF Act. Step 2. You get reemployed at a small, early-stage startup, a non-covered establishment where the Act might not strictly apply yet. Are your old funds stuck? No way. Step 3. You, the employee, request the transfer. And Step 4. Your old accumulations seamlessly move over to the credit of your account in that new Provident Fund, assuming the rules of the new fund permit it. The system is literally designed for mobility.
Okay, that brings us to Part 3, the price of non-compliance. We are pivoting from Act 1, the shield, to Act 2, the sword, and the stakes get a whole lot higher here.
We're looking at Section 14 now, and the penalties are incredibly severe. What really jumps out is that specific contraventions actually carry mandatory minimum prison sentences. If an employer defaults on the employee's contribution, they face a maximum of 3 years in prison, with a mandatory minimum of 1 year plus a 10,000 rupee fine. For defaulting on inspection charges, that's a maximum of 1 year with a minimum of 6 months and a 5,000 rupee fine. Even just making a false statement to avoid payment gets them up to a year. This incredibly strict enforcement shows the law definitely does not view these as mere administrative errors. Withholding employee funds is treated with the gravity of theft. And honestly, it doesn't stop with just those specific major violations. Section 14, subsection 2 establishes a baseline for general contraventions. If an employer defaults in complying with any general provisions of the scheme, the pension scheme, or the insurance scheme, the baseline penalty is up to 1 year in prison or a fine up to 4,000 rupees or both. The message from the law is crystal clear. Compliance across the board isn't optional, it is mandatory. Let's see how this builds with one critical number, 6. Under Section 14.3, the law casts an incredibly wide net to ensure absolutely no violation slips through the cracks. Say there's a contravention of the Act or some condition of an exemption, and there is no other penalty explicitly provided elsewhere in the text. Is the employer off the hook? Definitely not. They are still on the hook for a maximum of 6 months in prison, with a minimum of 1 month and a fine up to 5,000 rupees. There is simply no such thing as a freebie violation under the EPF Act. Finally, Part 4. When companies commit offenses. Let's look closely at Section 14A, liability. Now, what's really interesting about this is how the law treats the corporate veil. When an offense happens, companies usually love to hide behind that corporate structure, right? But under Section 14A, there is a strict, almost guilty until proven innocent nature of liability. If a company commits an offense, every single person who is in charge of and responsible for the business at that time is deemed guilty right alongside the company. You cannot simply fine the faceless corporate entity,
The law aggressively targets the actual human beings calling the shots.
So if you're an officer of the company, there are basically only two ways you can escape this personal punishment. You have to prove either that the offense was committed entirely without your knowledge, or that you exercise all due diligence to prevent it from happening. Think about the stark contrast here. Picture a truly diligent, proactive director who sets up robust compliance audits and checks, but is somehow defrauded by a rogue manager. They actually have a solid defense. Now contrast that with a totally negligent director who just turns a blind eye and assumes someone else is handling it. Yeah, that negligent director goes down with the ship.
Because Section 14A, subsection 2, doubles down on exactly that point. If an offense has been committed by a company, and it's proven that it happened with the consent, the connivance, or is simply attributable to any neglect on the part of any director, manager, secretary, or other officer, they will be personally proceeded against and punished. Connivance or neglect, actively participating in the fraud, or simply ignoring the problem because you couldn't be bothered to check, are treated by the law as equally punishable offenses.